is actually an important point, because the prevailing rule in the circuits, including the Fifth Circuit below, where this case is coming from, they didn't deny that there was clear notice. They said it would be unconstitutional because they thought that the officers were like, they treated them as non-recipients, even though they're basically indirect recipients, and it didn't sort of see that they fit within
well, not every circuit brought up the constitutionality question, but putting that aside, can you identify, putting aside the bribery cases, can you identify any cases in which a non-recipient of funds was held individually liable under a federal statute?
I mean, and I think in Grove City College versus Bell, you're reaching an indirect recipient. In Salinas, Dixon, Hess, and Laudani, those are all situations where you're reaching.
You can just say that, yes, it would be a different factual scenario.
I don't have a case that's on this exact factual scenario, I admit that, but I think actually this is like a lesser included of Salinas, and it's way inside Sabry. I mean, it's nowhere close to that.
But I said put aside the bribery cases. So
if I could push back on that a little bit, I think that's important. When the crux of this program is to provide federal funds to prisons that accommodate religious liberty.
Well, no, I asked you to put them aside because I wanted you to put them aside and look at the civil liability context for a minute. Okay, I think that Sabry and Salinas are the best cases for you, particularly Sabry. I take that. But if those are distinguishable, I wanted to ask you the other question, and I think the answer is no. And I think, and I just kind of want to clarify your answer to Justice Gorsuch, look, the facts of this case are egregious. So if on the facts we were looking for a case in which there should be money damages, this is it. Justice Gorsuch asked you a series of harder facts, harder factual scenarios in which we might think, I'm not sure if money damages as a policy matter make as much sense in that context. You never really gave him an answer, yes or no, and so I just want to say, I want you to give me an answer, yes or no, on Justice Gorsuch's hypotheticals, and don't fight the hypothetical about the conditions and all that. Your theory means that, yes, the coach, the doctor could be held liable.
Let me be clear about that.
Yes or no, yes or no.
The condition.
No, Mr. Tripp, he asked you to assume that the conditions, that it was perfectly consistent with the spending clause. So yes or no, would your theory say that, let's talk about the coach under Title IX, on Justice Gorsuch's hypothetical?
If the condition is valid,
yes. He said all that.
Yes. If the condition attaches, Congress can enforce it. And I think the crux of the question is,
okay, but just say yes or no, yes or no. You don't want to say yes or no. Just take the consequences. It's totally fine if those are the consequences. But I think you have to follow the logic where it leads. And the logic where it leads is that, yes, under Title IX, say, Congress could pass a statute, or Congress could say that it's going to rely on its spending power to hold the coach liable under the hypothetical Justice Gorsuch gave you, right? Yes.
Yes. But I think this is
I just don't see how you could say no, given the assumptions he asked you to make about the spending clause.
But I want to be clear. One of the reasons I've been articulating this rule under Salinas, right, which is these 4 ingredients, valid condition, officer within the scope, and threatening the program, is it doesn't require you to address, I think, some of these. There are hard hypotheticals about.
Well, Mr. Tripp, every time we decide a case, we have to think about what it's, in Salinas and Sabry, if they had looked ahead to this case, might have said, yeah, this might be where the logic leads, or you take a few steps from here and this is where it goes. But we can't decide a case just based on these facts, so you just need to own it.
No,
it's fine.
And I own that. I want to be clear about that. But what I'm saying, and the reason why, especially in our reply brief, we're relying heavily on Salinas, is you've already said all of this. And so we're not asking the court to break new ground.
But you're not making, well, okay.
And let's